This module is intended to assist Kentucky employers involved in the trucking industry in understanding OSHA. Although the information contained within this module addresses OSHA standards that are pertinent to the trucking industry, because of the potential variations that may exist in employers relative to occupational injury exposures and work site characteristics, it is impossible for any course to cover every aspect of those potential variations. Therefore, this module does not address all of the employer's legal obligations relative to occupational safety and health. Although this module covers part of the information that an employer must know to be effective in promoting a safe and healthful workplace, this course does not qualify anyone as a competent or qualified person according to OSHA standards. This module is entitled Introduction to OSHA. It is intended for employers within the Commonwealth of Kentucky that operate one or more commercial motor vehicles and hence are subject to the annual training requirements passed into law in 2013. This module is designed to provide trucking companies and other businesses that use commercial motor vehicles within the Commonwealth of Kentucky with an overview of OSHA. This training module was created for you by Midwestern Insurance Alliance, the workers' compensation carrier endorsed by the Kentucky Motor Transport Association, and the host of the website truckingworkerscomp.com. At the conclusion of this module is a brief quiz. When we speak of safety regulations within the trucking industry, most often we think of DOT regulations. But we shouldn't forget about OSHA. Prior to OSHA, workers had very little protection from hazards at work. Although there were various safety and health laws, they were inconsistent and only covered certain occupations. Furthermore, there was no effective method for enforcing those laws. By 1970, 14,000 deaths occurred each year from work-related injuries and illnesses, and 2.5 million workers were disabled. The high rate of injuries and fatalities, combined with the absence of consistent safety and health regulations, prompted Congress to pass the Occupational Safety and Health Act, which President Nixon signed into law in 1970. This law created the Occupational Safety and Health Administration, which we know today simply as OSHA. But the Occupational Safety and Health Act of 1970 did more than just create OSHA. It allowed for the creation of numerous entities, including an advisory committee, a review commission, an education and training division, and a research division which is known now as the National Institute of Occupational Safety and Health, or NIOSH for short. Although OSHA is a federal agency, the Occupational Safety and Health Act allowed individual states to set up their own state agency to establish and enforce safety and health standards. In states that have adopted their own state agency to establish and enforce safety and health regulations, it is the state agency, not federal OSHA, that governs safety and health within that state. Currently, there are 27 states that have a state-operated OSHA program. Kentucky is one of them. It's known as Kentucky Occupational Safety and Health and is part of the Kentucky Labor Cabinet. Most of the time, the safety and health rules in these states mirror the federal OSHA rules word for word. However, the states that have their own OSHA program are permitted to adopt their own safety and health standards or modify the wording of the federal OSHA standards to make them more stringent. Kentucky Occupational Safety and Health has 3 divisions: Compliance, Education and Training, and the Federal State Coordinator. The Compliance Division is staffed with compliance officers who are responsible for conducting inspections of workplaces in Kentucky. The Compliance Division is separated into 2 groups: Safety, which deals with the physical conditions such as machine guarding and exposure to falls, and Health, which deals with environmental conditions such as airborne chemicals or noise levels. The Education and Training Division is staffed with consultants, not compliance officers. These individuals are charged with helping employers understand and comply with safety and health standards. Like the Compliance Division, the Education and Training Division is separated into two groups, safety and health. The Federal State Coordinator Division does not have direct involvement with employers. Its role is to ensure that the Kentucky state-operated OSHA program is effectively coordinated with federal OSHA. For additional information about Kentucky's Occupational Safety and Health Program, go to www.kentucky.gov and type Occupational Safety and Health Program in the search field. There you'll find a detailed description of the program and contact information. For the first few years of its existence, OSHA didn't have safety and health standards of its own. Instead, it was allowed to adopt the voluntary standards that had been established by nationally recognized testing laboratories, such as Underwriters Laboratories, or what is known as consensus standards. Once adopted by OSHA, these standards could be enforced by OSHA compliance officers. After that, OSHA began creating rules of its own through a formal rulemaking process that allows for public comment and an economic feasibility assessment. There are 4 sets of OSHA standards, separated by industry. One applies only to construction industries. Another applies only to maritime industries. The third applies to agricultural operations. And the fourth is somewhat of a catch-all and is called the General Industry OSHA Standards. It is the general industry set of OSHA rules that apply to motor carriers and most other industries that have commercial motor vehicles. Additionally, OSHA standards include a set of record-keeping requirements that apply equally to construction, maritime, agriculture, and general industries. These are addressed in the module entitled OSHA Record Keeping. For now, let's take a look at the general industry standards, since those are the set of OSHA rules that most likely apply to your business. The general industry OSHA rules are broken into subparts based on the hazard or industry that they address. Here is a list of the current general industry subparts. By reviewing the various subparts of the OSHA general industry standards, you can likely see that some will apply to your business and some will not. For example, the subparts entitled General, Walking and Working Services, Emergency Planning, Medical and First Aid, and believe it or not, Toxic or Hazardous Substances apply to almost every employer. However, it's a relatively safe assumption that there's not many motor carriers in Kentucky that are involved in commercial diving, so nothing in that subpart would be relevant to them. Similarly, if your company does not have mechanics, it's unlikely that your employees weld or use hand tools, so those subparts would not be applicable to your company either. In the second column, you may have noticed that Special Industries is the name given to one of the subparts. There are a number of different industries addressed within that section, including logging, sawmills, bakeries, grain handling facilities, and more. However, trucking is not one of those industries. Therefore, the rules in that subpart would only be applicable to the extent that you haul to or from those industries and have some unique responsibility at the shipper or receiver locations that are addressed by OSHA's special industry regulations. Although there are many OSHA rules, it's impossible for OSHA rules to address every conceivable workplace hazard. However, Section 5A1 of the Occupational Safety and Health Act of 1970 is what is known as the General Duty Clause. In effect, the General Duty Clause operates to fill in gaps in OSHA rules, so that employers can be cited for hazards that are not specifically addressed by the OSHA standards. It states that each employer shall furnish to his employees employment and places of employment that are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his or her employees. Although the General Duty Clause fills in the gaps in OSHA rules, a common misconception is that OSHA can use the General Duty Clause to cite any condition that the compliance officer believes is unsafe. The truth is that several conditions must be met for OSHA to issue a General Duty Clause violation. First, the hazard must have been recognized. OSHA does not necessarily need to show that the employer recognized the hazard. For purposes of the General Duty Clause, a recognized hazard exists if the hazard is recognized by the employer or by the employer's industry. The existence of consensus standards or industry practices also can provide evidence that the hazard was recognized. Second, the employees must be exposed to the hazard, and they must be the employees of the cited employer. Third, the hazard must be serious, meaning that it could cause death or substantial physical harm. Lastly, a feasible method must be available to correct the hazard. In this context, feasible does not merely mean that it is technologically feasible. It also takes into account economic feasibility. For example, falls from flatbed trailers while tarping or untarping freight are a recognized hazard, and employees are exposed to that hazard every day at shipper and receiver locations throughout the country. Furthermore, we know that the use of tarp racks serve to protect employees from falls while tarping. However, it would be economically infeasible for a motor carrier to purchase and install a tarp rack at every shipper and receiver that his drivers deliver to. Although most workers are covered under the OSHA Act, there are some exceptions. These include minors who are covered under the Mine Safety and Health Act, or MSHA, self-employed persons with no employees, immediate members of farming families not employing outside workers, and public employees in state and local governments in some states. But what about trucking? Aren't trucking companies covered by DOT instead of OSHA? The answer to that depends on the situation. OSHA is preempted by Section 4B1 of the Occupational Safety and Health Act from enforcing its regulations if a working condition is regulated by another federal agency. Therefore, while traveling on public roadways, the Department of Transportation regulations apply and OSHA standards do not. However, when the truck is stopped or not operating on public roadways, OSHA standards may apply. For example, while loading and unloading trucks, OSHA regulations govern the safety and health of workers and the responsibilities of their employers. Therefore, while at a warehouse, dock, or construction site, and in all places truckers go to deliver and pick up loads, OSHA standards apply. Also, for the employees of trucking companies such as dispatchers, mechanics, yard jockeys, and others who are not operating a commercial truck on public roads, OSHA standards apply all of the time. Note that OSHA is preempted from enforcing its regulations if a working condition is regulated by another federal agency. However, since only another federal agency may preempt OSHA's jurisdiction, if the vehicle is an interstate truck and is not governed by federal DOT regulations, OSHA has jurisdiction. There are occasions in which the existence of a DOT rule will preempt OSHA, even when a truck is not traveling on public roadways. For example, OSHA has a regulation that states the brakes of highway trucks shall be set and wheel chocks placed under the rear wheels to prevent the trucks from rolling while they're boarded with forklifts. However, due to the DOT brake regulation, OSHA does not cite employers for failure to chock trailer wheels if the vehicle is otherwise adequately secured. In that situation, DOT's regulation preempts enforcement, and DOT has jurisdiction. Even though there's occasions when truck drivers are governed by DOT instead of OSHA, most employers, including most trucking companies, are required to keep records relating to work-related injuries, illnesses, and fatalities, other than minor injuries requiring only first aid. These records must be made available upon request by an OSHA compliance officer. These record-keeping requirements are addressed in the module entitled OSHA Record Keeping. Conveniently, OSHA has created a page on their website that is dedicated specifically to the trucking industry. To locate this page, go to OSHA's website, www.osha.gov, and type the word trucking in the search field. You'll be directed to a page that lists a wealth of information about preventing occupational injuries and illnesses within the trucking industry. There, you will find links to relevant OSHA standards, letters of interpretation, training presentations, research publications, and other resources. You'll even find links to compliance directives written to give OSHA compliance officers instructions regarding specific OSHA standards. It also offers a one-stop location to find applicable DOT and EPA compliance requirements related to worker protection. If you have not taken advantage of this resource yet, I encourage you to do so. So now that you know that OSHA standards apply even to trucking operations at least some of the time, it's helpful to understand how OSHA enforces their rules. Compliance officers may inspect a facility under one of 5 circumstances. 1. Imminent danger. In this scenario, a compliance officer observes a hazard that leads him to believe that a worker is at imminent risk of serious injury. For example, if a compliance officer drives by your facility and sees a worker being lifted on the tines of a forklift. 2. Fatality or hospitalization. As a Kentucky employer, you're required to notify OSHA if there's a fatality or if 3 or more workers are hospitalized from a single event. In such situations, OSHA will investigate the incident and will likely inspect your operation in the process. One exception to this is that OSHA typically will not investigate traffic accidents involving commercial motor vehicles, even when there is a fatality involved, as that is done by DOT. 3. Complaint from an employee. If an employee or an employee representative contacts OSHA and alleges that a hazard exists, and OSHA believes that there is reasonable grounds for an inspection, then a compliance officer will conduct an inspection. However, if OSHA does not believe that the hazard is serious enough to warrant an inspection, a letter will be sent to the employee or employee representative explaining the reason for not conducting an inspection. 4. Scheduled program inspections. Inspections that fall into this category includes those that are conducted of randomly selected businesses and those that focus on high-risk industries. Although any company doing business may be inspected, if your company or an operation within your business places you on one of OSHA's emphasis programs, you stand a greater likelihood of receiving an OSHA inspection. Lastly, follow-up inspections. These occur when the compliance officer has already conducted an inspection and is returning to ensure that the company has corrected the hazards. So what if an OSHA compliance officer shows up on your doorstep? A compliance officer, upon showing his credentials to an owner or person in charge, is authorized to enter any area where work is being performed by an employee to inspect the facility and conduct interviews. You may contact the office where the compliance officer is employed to verify their credentials. The OSHA inspection process will begin with an opening conference in which the compliance officer will explain the inspection process and the employer's rights and responsibilities. The compliance officer will then conduct a walk-around inspection or go straight to the accident site if the inspection was prompted by an accident. During an inspection, it's common for compliance officers to take photographs, make notes, interview employees, and even use special instruments to take noise or air samples. Inevitably, the compliance officer will ask to review various records, such as injury and illness records or written safety programs. When the inspection is completed, the compliance officer will meet with management to discuss unsafe conditions and possible violations. If citations are issued as a result of the inspection, they will be either hand-delivered or sent via registered mail within 6 months of the inspection. There's various types of citations depending upon the degree of severity and likelihood of injury. Therefore, 2 companies could be cited for the exact same violation, and one may receive a greater penalty than the other. The different types of citations are serious, other than serious, repeat, and willful. Citations classified as serious are those that the compliance officer believes that the hazard could lead to the hospitalization of an employee or a fatality. These types of citations begin at $7,000. Citations classified as other than serious are issued when the hazard is not likely to lead to the hospitalization of an employee or a fatality. Fines for these types of citations are up to $7,000. Willful or repeat violations are where an employer willfully or repeatedly violates a standard and can be issued a citation with a fine up to $70,000. In addition, if a willful or repeat violation leads to the death of an employee, the employer can be subject to imprisonment for 6 months or a fine of $10,000. As an employer, you can either pay the fines or contest the citations. If you decide to contest the citations, you must do so in writing within 15 days of receiving the citation. Additionally, employers who are issued an OSHA citation must post the citation in their workplace for a minimum of 3 days. It's important to note that compliance officers are not required to offer any assistance to help you come into compliance with OSHA standards. However, you may request compliance assistance from the Division of Education and Training. There are 3 types of assistance that the Kentucky Occupational Safety and Health Division of Education and Training provides. These are surveys, training, and technical assistance. Surveys are job site inspections conducted by the education and training consultants at an employer's request to point out hazards that are likely to cause serious injury or illness. Consultants who conduct these surveys also provide assistance on how to avoid or correct these hazards. They do not issue fines or monetary penalties. The only requirement is that the employer corrects serious hazards within 30 days. The training provided by Kentucky Occupational Safety and Health is conducted at your place of business at your request, and periodically at various locations throughout Kentucky. With respect to technical assistance, the Kentucky Occupational Safety and Health Division of Education and Training is ready to help Kentucky employers when they have questions relating to safety and health regulatory compliance. One advantage of having Kentucky Occupational Safety and Health consultants conduct a survey or teach classes for you is that these services are completely free. There's no charge for these services, whether it be a survey or training or technical assistance, and there's no limit to the number of times that you can request services from the Division of Education and Training. Although this module provided an overview of OSHA in Kentucky for motor carriers, there is no substitute for having the actual OSHA standards at your fingertips. You may request a CD from the Kentucky Labor Cabinet that contains all of OSHA's safety and health standards, including Kentucky's specific requirements, as well as posters, guidebooks, and other items. To request this CD, call 502-564-3070. This is the same number you can use to request an OSHA compliance survey, safety training, or technical assistance from the Division of Education and Training. At a minimum, contact the Division of Education and Training at this number and provide them with your contact information so that you're notified of free training seminars in your area. In this module, we discussed how and when OSHA came into being and how the OSHA standards are organized. We discussed when OSHA rules apply to trucking companies and when they don't. We discussed that in Kentucky, there is a state-operated OSHA program housed within the Kentucky Labor Cabinet that includes both a compliance branch and an education and training branch to help employers understand and comply with the OSHA rules. We discussed the OSHA inspection process, the penalty structure, and your options if you're cited for the violation of an OSHA rule. Lastly, we discussed some sources of information where you can gain a more comprehensive understanding of applicable OSHA rules. If you'd like assistance in complying with OSHA rules, I urge you to contact the Education and Training Division within the Kentucky Labor Cabinet, and to also contact the loss control staff of your workers' compensation carrier. Additionally, A number of OSHA compliance guides and sample OSHA compliance documents written specifically for motor carriers can be downloaded on truckingworkerscomp.com, a website maintained by Midwestern Insurance Alliance, the only workers' compensation provider endorsed by the Kentucky Motor Transport Association.